Order in the court. Judge Anthony Trenga's voice thundered through the packed federal courtroom as he slammed his gavel down. The sound echoed off the mahogany walls as all eyes turned to the confrontation unfolding before them. Judge Trenga leaned forward, his face flushed with barely contained anger as he pointed his finger directly at Congresswoman Jasmine Crockett. "I will not tolerate these theatrics in my courtroom, Congresswoman," he declared, each word dripping with condescension. For the past 10 minutes, he had been publicly dressing her down about proper courtroom procedure after she attempted to introduce new evidence in a high-profile civil rights case. The spectators watched in stunned disbelief as one of the most powerful federal judges in Virginia continued his blistering attack on the Congresswoman. What happened next left Judge Trenga visibly stunned and the entire legal community buzzing. Crockett calmly opened a leather portfolio that no one expected contained documents that would not only turn the case upside down but call into question Judge Trenga's entire judicial career. If you think powerful officials never face real consequences for their actions, what you're about to hear will change your mind forever. To understand why this courtroom confrontation sent shockwaves through America's legal system, you need to know who these two figures really are and why their clash represents far more than just a heated moment in court. Judge Anthony Trenga, 71 years old, has served on the United States District Court for the Eastern District of Virginia since 2008 when President George W. Bush appointed him. With his Georgetown law degree and background at one of Virginia's most prestigious law firms, Trenga built a reputation as a no-nonsense judge who ran a tight courtroom. Known for his conservative judicial philosophy, Judge Trenga gained national attention presiding over several high-profile national security cases. He's generally respected by the legal establishment with a reputation for being meticulous about procedural rules and sometimes harsh on attorneys he feels are unprepared. Throughout his career, he maintained close ties with business interests and conservative legal organizations, frequently speaking at their events. But here's what most people didn't know about the case where this confrontation occurred. It involved allegations of civil rights violations by a major corporation against minority employees. The plaintiffs claimed systematic discrimination in hiring, promotion, and workplace treatment, with damaging evidence that had survived multiple attempts by corporate defense attorneys to have the case dismissed. Judge Trenga had shown increasing skepticism toward the plaintiffs' claims in recent hearings, issuing several rulings that limited the scope of evidence they could present. Legal observers had begun questioning whether his handling showed implicit bias, though few would say so publicly about a sitting federal judge. Congresswoman Jasmine Crockett brought a dramatically different background to this confrontation. Now in her second term representing Texas, Crockett had established herself as one of the most formidable former attorneys ever to serve in Congress. Before winning her seat, she built an impressive 15-year career as a civil rights attorney and criminal defense lawyer. A graduate of the University of Houston Law Center, Crockett earned recognition for her work challenging corporate discrimination and representing communities whose civil rights had been violated. She was known for her meticulous preparation and innovative legal strategies that often caught opposing counsel off guard. The United States District Court for the Eastern District of Virginia was unusually crowded that Thursday morning. Extra chairs had been brought in to accommodate the overflow of spectators, many of them law students from nearby universities who had heard that Congresswoman Crockett would be presenting arguments. The room had the formal, hushed atmosphere typical of federal courts, with mahogany benches, the seal of justice prominently displayed, and the elevated bench where Judge Trenga presided. When the bailiff called the court to order, Judge Trenga entered wearing his black robe, his expression stern as he surveyed the packed gallery. "We're here to address the plaintiff's motion to reconsider the ruling on newly discovered evidence," Judge Trenga began, his tone already signaling his skepticism. "Though I must say, I find it unusual that Congresswoman Crockett has chosen to personally argue this motion rather than leaving it to lead counsel." "Thank you, Your Honor," Crockett responded, rising from the plaintiff's table. She wore a tailored navy suit, her demeanor calm and professional. "I appreciate the court's time in reconsidering this crucial matter." For the next several minutes, Crockett methodically outlined the legal basis for admitting the new evidence, citing federal rules of civil procedure and relevant case law with remarkable precision. Those in the gallery familiar with legal proceedings could tell she wasn't relying on notes. She was citing case numbers, dates, and specific legal tests from memory. Judge Trenga interrupted frequently, his questions becoming increasingly pointed. Congresswoman, I'm familiar with the Foreman decision, but it doesn't apply here because your team had ample opportunity to discover this evidence during the normal discovery period. The rules exist for a reason. We can't have parties introducing new evidence at every stage of litigation. With respect, Your Honor, Crockett countered. The Foreman decision specifically addresses situations where evidence was deliberately withheld by the opposing party, which is precisely what happened here. She opened a folder and approached the bench. If I may, this email thread shows defense counsel was aware of these documents 8 months ago and failed to produce them despite our specific discovery requests. But then Judge Trenga made the mistake that would change everything. Congresswoman Crockett, he said, his voice taking on a dismissive tone. While your advocacy is commendable, I think you may be out of your depth in federal court procedure. This isn't a congressional hearing where rules can be bent for dramatic effect. My courtroom operates on strict adherence to procedural rules developed over centuries of jurisprudence. The condescension was unmistakable, and you could feel the tension shift in that courtroom. Several of the law students looked uncomfortable, recognizing the inappropriateness of the judge's tone. But here's what Judge Trenga didn't realize. He had just challenged someone who had litigated over 100 federal cases before ever setting foot in Congress. Crockett remained composed, though those closest to her noticed her straighten her posture slightly. Your Honor, she replied evenly. Before serving in Congress, I litigated over 100 federal cases, including 8 that reached the Fifth Circuit. I'm intimately familiar with federal court procedures, and with all due respect, the rule you're citing doesn't say what you claim it does. The room grew completely silent. Challenging a federal judge so directly was almost unheard of, even among experienced attorneys. Judge Trenga's face flushed slightly. Enlighten me then, Congresswoman, he said, the sarcasm evident in his voice. Gladly, Your Honor. Crockett approached the bench again, this time carrying a different folder. Federal Rule of Civil Procedure 60b-2 specifically allows for reconsideration based on newly discovered evidence that with reasonable diligence could not have been discovered earlier. The key phrase is reasonable diligence, which your own ruling in United States v. Davidson defined as efforts that are appropriate to the circumstances and constraints faced by the party. She placed a copy of Judge Trenga's own ruling on the bench. You wrote this opinion just last year, Your Honor. Our team exercised reasonable diligence, but the defendants deliberately concealed these documents, as the emails I just showed you prove. Judge Trenga scanned his own words, visibly unsettled by having his ruling turned against him. The gallery watched as he shifted in his seat, clearly reconsidering his approach. But Crockett wasn't finished. Even if I were to accept that argument, Congresswoman, the evidence must be material to the case at hand. These additional employee complaints from other states don't establish a pattern relevant to our plaintiffs here in Virginia. This was the opening Crockett had been waiting for, and what she did next would expose corruption that went to the very heart of our judicial system. On materiality, Your Honor, I'd like to introduce one final document that establishes the direct relevance of these complaints. She retrieved a third folder from her table. This is an internal memo from the defendant corporation's HR director to their general counsel dated January 12th of last year. As she handed the document to the judge, she continued, it explicitly discusses the need to handle complaints consistently across all states to avoid creating a paper trail that could establish a national pattern of discrimination. This memo references complaints from all 7 states where similar issues were raised, including the specific complaints of our plaintiffs. Judge Trenga reviewed the document, his expression growing increasingly troubled. Where did you obtain this memo, Congresswoman? It wasn't included in your motion. It came into our possession yesterday evening, Your Honor. A whistleblower from the company's legal department contacted us after learning that you had denied our original motion. Crockett paused before continuing with words that would end a judicial career. The whistleblower was concerned because the company's attorneys had specifically mentioned to colleagues that they expected a favorable ruling from you on this matter before you had even heard our arguments. The courtroom erupted in whispers. Judge Trenga banged his gavel sharply. Order. I will not have such insinuations in my courtroom. Congresswoman, that borders on contempt. I'm not making insinuations, Your Honor. I'm stating facts supported by evidence. Crockett returned to her table and retrieved a final folder. And that brings me to the most troubling document of all. The tension in the courtroom was now suffocating as Crockett approached the bench with her final piece of evidence. Your Honor, this document came to us through the same whistleblower. It's an email exchange between the lead defense counsel and the company's CEO discussing their litigation strategy. As Judge Trenga began reading, his face visibly paled. The email specifically mentions, and I quote, Judge Trenga has been a reliable ally in these matters since his appointment. His former law firm still represents our subsidiaries in 3 states, and his financial disclosures show he maintains investments in our parent company. He can be counted on to exclude the cross-state evidence on procedural grounds. The courtroom fell completely silent. The implications were staggering. Congresswoman, these are serious allegations that have nothing to do with the admissibility of your evidence. With respect, Your Honor, they have everything to do with it, Crockett replied firmly. Federal law requires judicial recusal when a judge has any financial interest, however small, in the subject matter of the case or in a party to the proceeding. Your financial disclosures, which are public record, show investments in Transcorp Holdings, the parent company of the defendant. She produced copies of Judge Trenga's own financial disclosure forms. Additionally, 28 U.S.C. Section 455A requires recusal in any proceeding where your impartiality might reasonably be questioned. The fact that your former law firm currently represents the defendant's subsidiaries creates precisely such a situation. The defense attorneys jumped to their feet. Your Honor, we object to this ambush. This has nothing to do with the motion before the court. On the contrary, Crockett responded before Judge Trenga could speak. It has everything to do with it. The legal standard for reconsideration includes whether justice requires revisiting a prior ruling. When that ruling was made by a judge who failed to disclose conflicts of interest, justice absolutely requires reconsideration, not just of this motion, but of every ruling in this case. Judge Trenga sat stunned, the confidence and condescension completely gone from his demeanor. After what seemed like an eternity, he spoke in a subdued voice. This court will take a 30-minute recess. I need to consult with the chief judge regarding these matters. He rose abruptly and exited to his chambers, leaving behind a courtroom buzzing with shocked conversations and the career-ending documents that would change everything. When Judge Trenga returned, his face was grave. Beside him was Chief Judge Rebecca Hollis of the Eastern District of Virginia, a highly respected jurist known for her commitment to judicial ethics. In light of the serious matters raised, Judge Trenga began, his voice subdued. I am recusing myself from this case effective immediately. Chief Judge Hollis will address the court. Judge Hollis stepped forward with the authority of someone who had seen it all. This court takes allegations of judicial misconduct and conflicts of interest with the utmost seriousness. I will personally review all evidence presented today and have already contacted the Judicial Council of the Fourth Circuit regarding an ethics investigation. Congresswoman, your motion to admit the new evidence is granted. Furthermore, I am ordering a complete review of all previous rulings in this case. This matter will be reassigned to Judge Williams, who has no connections to any of the parties involved. As Crockett gathered her papers, the implications of her victory were clear to everyone present. What had begun as a routine procedural motion had exposed serious ethical breaches that would forever change Judge Trenga's career and potentially affect dozens of his past rulings. Outside the courtroom, as reporters surrounded her, Crockett remained measured and professional. This case was never about a personal confrontation. It was about ensuring that our judicial system works fairly for everyone regardless of their wealth or connections. When the rules are applied equally, justice prevails. The aftermath was immediate and far-reaching. By that evening, every major news outlet had broken the story. Within 48 hours, the Judicial Council of the Fourth Circuit announced a formal investigation into Judge Trenga's financial disclosures and potential conflicts in dozens of cases. The U.S. House Judiciary Committee launched a parallel investigation into broader patterns of undisclosed conflicts among federal judges. For Judge Trenga, the consequences were swift and severe. He announced a leave of absence and began recusing himself from over 30 active cases involving any connection to his investments or former law firm. The ripple effects of this confrontation extended far beyond a single courtroom. The precedent Crockett set transformed how the legal system handles judicial conflicts of interest. The Administrative Office of U.S. Courts announced new, more stringent requirements for judicial financial disclosures. Law schools across the country incorporated this case into their legal ethics curricula. Georgetown Law created a special seminar titled Advocacy and Ethics, when challenging judicial conduct is necessary. For the original plaintiffs in the discrimination case, the impact was life-changing. Under the new judge, the evidence was fully admitted, creating a comprehensive picture of systematic discrimination. Within 3 months, the corporation agreed to a historic $175 million settlement and committed to court-monitored changes in hiring and promotion practices. Perhaps most significantly, this case sparked a national conversation about accountability in the judiciary. A Gallup poll conducted 1 month later showed that 83% of Americans believed federal judges should face stricter ethics requirements. 6 months later, bipartisan legislation called the Judicial Financial Transparency Act was introduced in Congress, requiring more comprehensive disclosures and establishing an independent review board for judicial ethics. For Congresswoman Crockett, this incident fundamentally changed her national profile. She became recognized as one of the foremost legal minds in Congress, inspiring law students and young attorneys, particularly women of color, who cited her as proof that combining public service with unwavering ethical advocacy was possible. The whistleblower who provided the crucial evidence, Melissa Chun, came forward 2 weeks later. In interviews, she explained her decision. When I saw how the company's lawyers were boasting about their influence over Judge Trenga, I knew I couldn't stay silent. This wasn't about politics. It was about right and wrong. 1 year later, the final chapter of Judge Trenga's career was written when the Fourth Circuit Judicial Council completed its investigation. They found that he had failed to disclose conflicts in 37 cases over a 7-year period. Rather than face potential impeachment proceedings, Judge Trenga announced his retirement from the federal bench. In his retirement statement, he acknowledged errors in judgment. While I have always strived to uphold the highest standards of judicial conduct, I recognize that my failure to properly disclose certain financial interests has undermined public confidence. Our justice system depends on such confidence, and I regret any damage my oversights may have caused. The lasting legacy of this confrontation was perhaps best captured by a first-year law student who had been present in the courtroom that day. In an essay that went viral on social media, she wrote, "What I witnessed wasn't just a legal argument. It was a masterclass in moral courage. Congresswoman Crockett showed me that being a great lawyer isn't just about knowing the law. It's about having the courage to ensure the law works equally for everyone, even when that means challenging the most powerful figures in our justice system." For millions of Americans who had grown cynical about accountability for those in positions of power, the Crockett-Trenga confrontation provided a rare and inspiring counterexample. It was proof that preparation, courage, and adherence to principle could still overcome entrenched privilege and restore faith in the possibility of equal justice. This story shows us that when knowledge meets courage, even the most powerful institutions can be held accountable. When we demand transparency and ethical conduct from our leaders, we strengthen the very foundations of our democracy. Because in the end, justice isn't about who has the most power or influence. It's about who has the courage to stand up and demand that the rules apply equally to everyone.